So now, having understood few theoretical or conceptual issues, I welcome you to the selected case laws. Let us first look at the case insert systems incorporation versus instruction set. In this case, insert system sued the defendants in Connecticut, that is the petitioner's hometown, for trademark infringement, even though petitioners had no assets in Connecticut and was not physically transacting business there. The Federal District Court determined that it had specific personal jurisdiction over ISI. Year after that, ISI is nothing but Insert Systems Incorporation in Connecticut, basing its determination on ISI's use of toll-free telephone number and the fact that there was at the time 10,000 internet users in Connecticut, of all whom had ability to access ISI website. There was it's proved that there was access by 10,000 internet users accessing into the ISI's website. The court specifically mentioned that defendant had purposefully availed himself of the privilege of doing business in Connecticut in directing advertising and its phone number to the state simply because subscribers could access the website. So there is proof that purposeful availment test is proved here actually, which is connected very much because there are 10,000 users are used the service of insert systems. The second case, which is interesting and most famous case in the world, which we can deal now, Zippo Manufacturing Co. versus Zippo.com Incorporation, 1997 case. It's interestingly to understand exactly what the models which we are discussing this time. In this case, the court's task was to determine whether defendants conducting of e-commerce with Pennsylvania resident constitute the purposeful availment of doing business in Pennsylvania. Defendant not only chose to process Pennsylvanian resident application but also assigned them password. The defendant argued that its forum related activities were not numerous or significant enough to create a substantial connection with Pennsylvania. It pointed out to the fact that only 2% of its subscribers were Pennsylvanian residents, and the court concluded that this level of contact with the state justified in the exercise of specific personal jurisdiction. It's proved that there are involvement, there are personal jurisdiction involved in this case. That's why the court is taking absolute stand. The court also noted that the case reveals a sliding scale in which at one end of the spectrum are situation where a defendant early does business over the internet. If the defendant enter into a contact with residents of foreign jurisdiction that involve knowing and repeated transmission of computer files over the internet, personal jurisdiction is proper. The sliding scale approach classifies the website on the basis of interactivity. You must be knowing that in the taxation and also in the medicines, while giving injection to the patients, also we use the method called a sliding scale. Even the taxation authorities also use put appropriate taxes on the payer, and also when patient is admitted to the hospital, also there is they use the sliding scale applying medicines also. That kind of methods used by the honorable court in the Zippo manufacturing case to understand the interactivity, which is well proved actually. And then we have another one, Compass Serve Inc. versus Patterson, 1996 case. This case involved a computer network service provider coming under Ohio law, which sued subscriber with whom it had entered into agreement to register the subscriber shareware computer software for third parties to use the purchase on the web. Plaintiff sought declaratory judgment that it had not infringed on the subscriber common law trademarks engaged in unfair competition. It was held that defendant also repeatedly sent his goods electronically to plaintiff in Ohio for ultimate sale, and after deciding that the plaintiff's product infringed on its software, repeatedly sent messages to Ohio outlining his claim. So there is a interactivity again in this case, which well proved. And the another one case which is important also, which we can discuss at this moment, International Shoe versus Washington. Case involved a Washington court attempting to assert jurisdiction over a corporation that was incorporated in Delaware had a principal place of business in Missouri, but rather a simple test of proportionality has been employed for the purpose. The court observes the likelihood that personal jurisdiction can be constitutionally exercised is directly proportionate to the nature and quality of commercial activity that an entity conducts over the internet. So, the commercial activity and the physical presence of a service provider, there can be also proportionality test where how much interaction is happening via internet also can be helpful through this case. And the next case which gives a kind of illustration to understand our model again, the case laws, Cyber Cell Incorporation versus Cyber Cell Incorporation. It is a 1999 case. The court held more operation of a website is insufficient to support personal jurisdiction. Something more is required to indicate that the defendant purposefully directed his activity in the substantial way to forum state. Forum state again, creating some kind of challenges at this moment, like whether they are empowered to try the cases which arises out of cyberspace. Then we have another one case, Quokka Sports Incorporation versus Cup International Limited. It is in the case held in 1999. Defendant, company and individual based in New Zealand, operated website under the domain names that alleged infringed plaintiff trademarks. The court found that the content of the website reflected the defendant's intention to target the US market. New Zealand based persons moving to United States and starting a business.com, which is generally given in the United States, but in case of New Zealand they are supposed to start like .nz and all to know that the origin of the company from the New Zealand, but this company went to the America to target the American consumer. They also American consumers started availing the service of this Cup International Limited, and then it is proved that they have targeted the American customers, and the consideration created very much so the company was liable to pay the penalty which is asked by the court, which we can see like purposefully went to the United States to register according to the court observation. The website featured banner advertisement from the 10 US companies. The defendant quoted advertising rates to prospective advertise in the US dollars. The website offered to sell travel packages that were priced in the US dollars. They are all proved by the court of law that this company have indulged into access to the consumer world of America, United States of America. And the next case, which is Indian case in 2003 decided, that is Casio India Company Limited versus Ashita Telesystems Private Limited. In this case, the plaintiff was aggrieved by the registration of the domain name of the defendant with its registered office in Mumbai. It filed a suit of trademark infringement in Delhi High Court on the issue of territorial jurisdiction. Defendant contended that it carried on business in Mumbai only, not cause of action arose in Delhi. The plaintiff, however, averred that the website could be accessed from Delhi also. The court observed that once access to the impugned domain name website could be as from anywhere else, the jurisdiction in such matters cannot be confined to the territorial limits of the residence of defendants. This test used by the court is very much supporting the case law which we discussed today, that internet does not have any kind of universal jurisdiction and it is an imaginary space. So, any person who is accused or alleged by using the internet space, deceiving the consumer, deceiving any other fellow colleagues involved in the business, it's understood that internet does not have a universal jurisdiction. That is also a challenging moment which arises out of this Casio India case. And then we have another Indian case, Modi Entertainment Network and ANR versus WSG Cricket Private Limited. In the case, Delhi High Court has taken on the issue to elaborate upon doctrine of anti-suit injunction as meaning to wherein a court can direct a party not to pursue the matter before another court. It is appears to be like normal injunction which is given by the party not to. Court has always power to say that if there is a case pending in any other court and then there is a problem in filing in another court, it is a common ground that the court in India have power to issue anti-suit injunction to a party over whom it has personal jurisdiction in an appropriate case This is because courts of equity exercise jurisdiction in personam. However, having regard to the rule of committee, this power will be exercised sparingly because such an injunction through directed against a person in effect causes interference in the exercise of jurisdiction by another court. SMC Pneumatics India Private Limited versus Jogesh Katra. In this case, the Delhi High Court assumed jurisdiction where a corporate reputation was being defamed through emails. Further, the Information Technology Act also provided for extension of a code to extraterritorial offences. The provision of this code play also an offences committed by any person in any space without and beyond India committing offence targeting a computer resource located in India. It further defines the word offence includes every act committed outside India, which if committed in India would be punishable under this code, whether it is inside or outside India, but using the computer punishable under the code. This is the test. So, having understood the case laws which we have been discussing in this module, and once again, like I would like to emphasize on the objectives also, which will be connecting with what kind of outcome we get. With the internet revolution, cyber world have become part of big strata of the population. With convenience of the internet comes to the question of jurisdiction. Jurisdiction issues per se raises more questions than the answers, as you know, basically because we all use internet and it's becoming like netizens now. We are more like, though we are citizens, but we are now called more netizens using the apps, computer based apps in everyday life, whether come to banking, education, or even running our basic life also in the era of service industries. That's why and clubbing without the physical presence of the defaulter criminal with the help of cyberspace, the question of jurisdiction adds another dimension to the existing knowledge of space. The basic objective, as we have understood in this module also, the true meaning and type of jurisdictional issues involved with the internet or cyberspace. And as you have been listening to the various models which are discussed, have been discussing by our colleagues all over the India. I hope you also like this model, and also which can also lead to further queries, debate, and then more learnings also. And most of the time we say like the learning outcome in this emerging area of studies like cyber laws, under that we talk about the case laws and the jurisdictional issues. It's all emerging and appears to be very new, and there is a responsibility of all teaching and lawyers and the student community or other stakeholders to come together to understand like the clarity in terms of the jurisdiction in the cyberspace with the help of several case laws, which is the real outcome of this module. I hope you enjoyed the model, and which is subject to further query, clarification, and debate. And thank you very much for having your passion listening this model, and thank you.